Good afternoon, members. It's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee. Let's first invite representatives of the administration to come inside the conference room. The public officers in attendance are Deputy Secretary for Health, Ms. Elaine Mack, Principal Assistant Secretary for Health, Mr. Derek Lee, Assistant Secretary for Health, Mr. Emmanuel Lam, Professor Agnes Terrari, Chairman of the Nursing Council of Hong Kong, Ms. Lucia Ko, Principal Nursing Officer of the Department of Health, Ms. Harriet Chen, Secretary Nursing Council of the Department of Health, Ms. Vicky Chen, Assistant Secretary Nursing Council, Department of Health, Mr. Denny Tong, Chief Manager Nursing / Chief Nurse Executive Hospital Authority, Ms. Celia Ho, Senior Government Counsel, Department of Justice, and Ms. Candy Cheng, Government Counsel, Department of Justice. The administration has submitted a paper. It is a response to issues raised at the meeting on 30th of April 2024, LC paper number CB brackets 4610/2024 brackets 01. Will the administration brief members on the paper? Thank you. Our response is relatively simple. On our processing of applications for full registration, in relation to declarations as to whether the applicant has been convicted in Hong Kong or elsewhere, based on member suggestions, we will in future promulgate guidelines for applicants' reference. We also want to mention specifically, we want to clarify something. That is whether the Council can approve or reject an application without holding an inquiry in a case where the applicant declared that they had in Hong Kong or elsewhere been convicted of an offense punishable with imprisonment. The Council will definitely hold an inquiry to see if they will exercise a discretion when processing the application. I have nothing else to brief members on. We're more than willing to take members' questions if there are any. Members, do you have any questions? If not, I have a question myself about whether the Council can approve or reject an application without holding an inquiry in a case where the applicant is guilty of a criminal offense or professional misconduct. But I understand that the inquiries will be held only for those with full registration, not limited registration or special registration. Is that correct? So if someone is overseas and has declared that they have been convicted of a criminal offense or a professional misconduct overseas, will an inquiry be held? Chair, thank you. The non-locally trained nurses, if they are applying for limited registration or special registration, they will be engaged by the specific institutions, and in law we will say specifically they have to be of good character. So depending on the evidence provided by the applicant or the institutions, we will not hold inquiries for them. All right, thank you. Any other questions from members? I can see that a document has been tabled, Nurses Registration Amendment Ordinance 1997. Can you explain why this is tabled or how we are to deal with this? I'll let Mr. Lee talk about this. Thank you. When we got to the end of the meeting, we talked about some provisions for Nurses Registration Amendment Ordinance 1997, what the uncommenced provisions are, and what the specific provisions that are to be amended. So we have printed this for members' reference. All right, thank you. If there are no other comments from members, please proceed with clause-by-clause examination. Thank you, Chair. We are now at section 22, page 53 of the marked-up copy. Section 22 on appeals. Simply put, Section 22 has set out in 5 aspects an appeal mechanism. That is, people may lodge appeals with the Court of Appeal. For example, a person who is aggrieved by the Council's decision to reject the person's application for registration, for enrollment, special registration, as well as limited registration or enrollment. Also, people can lodge appeals in relation to the Council's decision to reject the person's application for a practicing certificate and an order made under Section 17(1) upon an inquiry. We have made a particular change for these 5 categories of decisions made in subsection 1. In January, the legal advisor also asked about for the categories A to E. They do not include for section 21(4). That is restoring the name of a person who has been removed from the register. If a person's name is removed from the register indefinitely, one can apply to the Nursing Council to restore their name to the register. The council would have to make a decision. But it seems to be the case that it has not been included in the amendment. That's why we will propose an amendment in future for subsection 1. We will submit the draft amendments at the next meeting. For section 22, subsection 2, that is in accordance with section 21. This will not include the decision for restoring one's name to the register. That's why we will also amend subsection 2 in the proposed amendments that are to be submitted at the next meeting. Thank you. Let's proceed. Page 54 of the marked-up copy, penalties for assumption of title of nurses. That is section 24. These are just technical amendments. We are just trying to tidy up the profession. After that, when we talk about the 1997 Amendment Ordinance, you should be able to see that the penalties have been increased for section 24. We will talk about that later. Alright, next, page 56 of the marked-up copy. Exemptions from registration. Right now, there are 2 groups of persons that can be exempted. 1, persons serving in the Chinese People's Liberation Army in the capacity of nurse, and persons in full-time employment by the government in the capacity of nurse while acting in the discharge of their duty. We suggest repealing this subsection B. Thank you. Please proceed. Next, it would be section 27. We have some amendments with the text. As we have already defined secretary to mean secretary for health, that's why we have deleted the parts for health. I have a simple question here for subsection 3. Subject to the approval of the Secretary, the Council may, by regulation, provide for. When you talk about by regulation, is it the case that you would make use of subsidiary legislation? Correct, it would be by regulation. Thank you. I have no other questions. Any other questions from members? If not, we'll proceed. Thank you. Page 59 of the marked-up copy. Starting from there, we have some new provisions. Sections 28 to 31. These are miscellaneous provisions. I will first talk about the proposed section 28. This section will empower the Council to specify forms for applications and certificates or other documents. We believe it is a principle adopted in drafting, allowing the Nursing Council to specify forms for related documents. Thank you. I believe there are no other questions. Excuse me, Mr. Lighton Kwok. I want to ask for the word use. It is form, but it actually means format in Chinese. Is it the case that you would often make use of forms in English? There is a disparity between the Chinese and English versions. The Chinese word use is format, and the English word use is form. Is it the case that it is a convention in drafting as well? Thank you. Thank you, Chair. I will let the DOJ colleague answer this question. All right, please. Thank you. Thank you for the question. Form can mean just a form or format in law, and in section 28, the Council may specify the form as in format for making an application or a certificate, but it can also mean format, or a form specifically. So it can mean both. For example, in subsection 1b, it would be different because it points to multiple documents. That's why we have adopted a wider definition with the word form. As for the Chinese word format that is used, this is often used in other legislation as well. Mr. Lai, do you accept this answer? Yes, thank you, Chair. All right, let's proceed. Thank you, Chair. We're now on page 60 of the marked-up copy for the proposed section 29. It is about the Secretary may give directions if the Secretary considers it is in the public interest to the Council in relation to the performance of its function or the exercise of its powers. Let me stress this. The Nursing Council has all along been professional and cooperative with the government. We propose section 29 only because we want to make sure there is a legal basis for collaboration between the government and the Nursing Council for the formulation of healthcare policies. And with this section, this should facilitate such collaboration. And this is the policy intent. Thank you. If you have no other questions, we'll proceed.
同一頁亦都係60頁第。
On the same page, page 60 of the English version of the marked up copy, section 30. Under this section, the Secretary may, by notice published in the Gazette, amend Schedule 1 or Schedule 2. This will be done by way of negative vetting. Schedule 1 is about the list of specified institutions, and Schedule 2 are the designated institutions. Section 31 is to provide for transitional provisions. There are some transitional provisions that have to be retained as we amend the ordinance, and we will come to this later. Now we come to Schedule 1. It lists out the specified institutions for nurses under special registration. They include Department of Health and the Hospital Authority. Schedule 2 is the list of designated institutions. There are two parts to this. Part 1 involves Department of Health and the Hospital Authority. Part 2 are training schools, residential care homes for elderly as well as persons with disabilities. Also, scheduled nursing homes as well as institutions needed are included in Part 2. I remember members asked questions about this schedule. For special schools that need nurses, can nurses under special registration be recruited by these schools? Mr. Lai Tong Kwok. Thank you, Chairman, for raising this question. Here in point 5, it says that the Council can exercise discretion to allow institutions under the schedule to recruit nurses under limited registration. What are the standards to be applied by the Council? When institutions come to you, what are the procedures if they want to recruit nurses? Well, there were no previous examples of these, but we might see such cases in the future. I understand that some special schools would like to recruit nurses under limited registration. According to the government, if necessary, the Council may consider approving the applications of institutions needed. Can you tell members of this committee what kind of criteria or standards you would adopt when you consider the applications? This would give us a better idea. The way you're drafting it now is giving a lot of power to the Nursing Council. We have no idea how the Council would exercise the discretion, and this is not ideal. I want to know how the government is interpreting this part of the bill. Deputy Secretary, we have made reference to the Medical Registration Ordinance as well as the Dental Registration Amendment Bill, which is now being scrutinized. In this context, this concerns nurses under limited registration, and we empower under the bill the Nursing Council to publish notice in relation to nurses under limited registration. Take medical practitioners as an example. There are doctors under limited registrations. Say for rugby sevens, there are doctors who have to come to Hong Kong with the delegations. There were also some large-scale works that involve imported workers and professionals, and there were arrangements in which doctors came to Hong Kong through limited registration so that they can provide services for the designated groups in Hong Kong. Say for the Medical Council, they would see if it is appropriate to approve the applications, and they would see whether the doctors who are here to provide services have met the relevant criteria and qualifications. So the Medical Council also imposed certain restrictions and requirements on doctors under limited registration. We are proposing this provision in this bill because we envisage that in the future there might be emergency situations in which the Council would have to make a quick decision to approve nurses under limited registration. Like other councils, the Nursing Council would consider whether it is necessary to approve such nurses and whether the nurses who are going to come to Hong Kong have obtained the relevant qualifications. The Council would consider whether it is necessary to approve the limited registration application for such nurses. I believe the Nursing Council would, like the Medical Council, publish a notice themselves about their decision. Chairman, I thank the administration providing some examples to illustrate this provision. It seems like this part of the bill is out of tone somehow. Points 1 to 3 are about designated institutions or other institutions in need of nursing care. However, for point 5, you are telling me that you are going to approve the applications on a case-by-case basis. Point 5 is completely different from the scenarios under points 1 to 4. By just reading this provision, we get the feeling that point 5 deals with special circumstances. That's why a member wrote to you to ask about applications potentially submitted by special schools. You didn't say that such applications would not be approved. You told us that the applications would be considered on a case-by-case basis. If appropriate or necessary, the Council might approve such applications. And the reply the government gave us, as well as the explanation you provided, were not consistent. So the way point 5 is drafted here covers a very broad scope. I don't exactly get what kind of scenarios or circumstances point 5 would cover. If you would approve applications under all scenarios, that's fine. Or if you allow the Council to exercise discretion under certain circumstances, that's also fine. But you have to spell it out clearly in the provision. In the future, when an institution comes to you or to the Council to make an application, would you approve the application? That's the question. I want the administration to think about whether there is a need to further refine this provision. Deputy Secretary, anything to add? Thank you, Chairman. I understand where the member is coming from. We will see whether there is room for us to refine this part of the provision. The policy intent is that if there is a need for nurses under limited registration or special registration to serve in a particular situation, we might allow them to do so by way of subsidiary legislation. And this includes situations where social welfare organizations may be in need of nurses. As for the case about special schools, I think at this moment we don't really know what the arrangement would be like. As explained to members previously, we think we'll have to discuss with the nursing council to see how we can have non-locally trained nurses to work at special schools in Hong Kong. We will see how we can refine the provision here to better reflect our policy intent. But at the moment, our goal is to provide flexibility so that we can provide nurses to institutions in need of such services. Say, the government or the council make use of its power under point 5. If a gazette is to be published, would it be done by way of negative vetting or subsidiary legislation? If you look at Part 3 of Schedule 2, point 5 of Part 2, it doesn't fall under a subsidiary legislation. Well, the legal advisor understands it correctly. Ms. Rebecca Chen, I'd like to ask about point 4 of Part 2 of Schedule 2. For nurses under limited registration, which institutions can recruit or hire nurses under limited registration? Well, Part 2 specify that residential care homes for persons with disability and the elderly may recruit nurses under limited registration. But point 5 here is a bit different. It allows the nursing council to specify certain institutions to allow them to recruit nurses under limited registration. According to Cap 164, what are the duties or terms of references of the nursing council? The nursing council has to make sure whether nurses have obtained relevant qualifications or whether they have been registered. Also, according to the ordinance, the nursing council will have to make sure that nurses have gone through or attended courses or programs that they are required to attend. As to whether the nursing council has the power to decide whether an institution can recruit nurses under limited registration, well, the nursing council is supposed to be responsible for the quality of our nurses, etc. But now we're giving the power to the nursing council whether an institution can recruit nurses that are not locally trained. Shouldn't it fall under the purview of the government? How come the power is now given to the nursing council?
Thank you. Our understanding is that for those under limited registration or enrollment, it is important to make sure that the nurses are professionally qualified. And under the provisions for nurses on limited registration or enrollment, they have to fulfill certain conditions. For point 5 in particular, it is to remain flexible so that for institutions not included in points 1 to 4, we can catch them under this provision. should such institutions need nurses on limited registration or enrollment. In fact, for different medical professional bodies, we have allowed the bodies to introduce non-locally trained professionals. We believe the Nursing Council will adopt their professional knowledge when considering which institutions to be appropriate or necessary. But we will review the member suggestion after the meeting. Chair, I have a follow-up. I do understand that this 0.5 would be a catch-all provision, and I am saying, and I want a direct answer from the administration, is that the power of the Nursing Council should not include which institutions should be designated. That is, they should not make the decision as to which institution to be designated when that can recruit non-locally trained nurses. They can have powers to determine whether nurses are qualified. They can conduct disciplinary inquiries and whatnot. But they should not have the power to designate institutions that can recruit non-locally trained nurses. I respect the Nursing Council. They have been working very well in ensuring the nurses working in Hong Kong are qualified. I think, however, the power of the Nursing Council should not include the power to designate institutions that can recruit non-locally trained nurses. We are scrutinizing the Nurses Registration Amendment Bill, and I understand why the administration has mentioned, because we are scrutinizing other bills as well, the other medical professional bodies' experience. But we're scrutinizing the bill related to nurses. We should look specifically at the Nursing Council's powers under Chapter 164, and they should only review the standards of nurses. The power to designate institutions to recruit nurses should remain with the government. Why is it decided by the Nursing Council? This is my question. Why is it the case that the Nursing Council would have such power? This is my only question. Why does it not lie with the government? I agree. If the Nursing Council does not have much room in determining whether someone is valid for limited registration or enrollment, I think the Nursing Council should or does not have the power to do so. Thank you. Well, thank you, Chair. I understand that the bill focuses on the Nurses Registration Amendment Bill, but when we drafted the bill, we have made references to the Medical Registration Ordinance as well as the other bill for dentist registration. In 2C, we did talk about the definition of designated institutions. That is page 6 of the marked up copy. As for the role that the Nursing Council plays and the purposes of the Nursing Council, we would say this: the power to designate institutions would fit the role that the Nursing Council plays. I'll see if the DOJ colleague has anything to add, but from a policy perspective, we believe it is appropriate for the nursing council to make such decisions, and they should have such flexibility when exercising the power. Chair, do we need the DOJ colleagues to supplement our answers? Yes, please. Thank you. Under Chapter 164, it would mainly be Section 3 that would play a part. For subsection 1, for the purposes of this ordinance, there shall be established a council to be known as the Nursing Council of Hong Kong. That is, the functions of the council would be to exercise the powers under this ordinance. And in this ordinance, there are no specific provisions on the functions and the role of the nursing council. So from the provisions, the nursing council can exercise certain powers and their functions essentially with the powers given by the ordinance. And regarding point 5, that is, the council may by notice published in the Gazette designate institutions. By such information, they will not be specifying the names of the institutions. They will only talk about the types of employment. If the nursing council considers such types of employment would be appropriate for nurses on limited registration or enrollment to be introduced, then it would be the case. It would not be the case that names of institutions would be published. Chair, I find the explanation very confusing. I asked specifically about special schools, and special schools are not included in points 1 to 4, so they should fall under point 5. So is it the case that you would designate a certain post of special schools? I have actually no problem with that. I understand the nursing council would have power to say a nurse would be valid for limited registration or enrollment. And I think what they said about designated institutions, the power to designate institutions should lie with the government. I don't know if I misunderstood the DOJ colleague's explanation. What I'm asking is very simple. The power to designate additional designated institutions. Who would be the one responsible for doing that? Is it the nursing council or the government? It seems to me from the provisions it would be the nursing council. Thank you, Chair. I think we can perhaps look to 2C and the picture would be clearer. For the meaning of designated institutions, it would be those that are specified in Part 1 of Schedule 2. It falls within any of the categories of institution specified in Part 2 or Schedule 2, or it is designated as such by the Secretary by notice published in the Gazette, or it is designated as such by the Director of Social Welfare by notice published in the Gazette. We have not mentioned specifically what the institutions would be, because if it is in the public interest or if there are urgent needs, we can designate other types of institutions. We want to remain flexible here. And what the DOJ colleague said, with the power given to the nursing council, they can designate the types of employment in particular. Of course, it would involve certain institutions because the nurses would have to work at institutions, but it would be a narrower sense because only the types of employment would be specified. All right. Chairman, I would need to digest such information. I'll let other members ask their questions first. Thank you. Professor Chen Wing-Kong, thank you. Echoing on what Ms. Chen Hong-Yan asked, in fact, several members of the DAB have written to the Bills Committee asking if it is possible for special schools to engage nurses on limited registration or enrollment. If we have not specified in particular which government department would be responsible, often it would seem that it would fall to the nursing council to exercise such powers. I have worked on the boards of many bodies. When it comes to the professional matters, of course, we would know what is going on, but the broader matters, we should not have the power to see if it is suitable. In this case, is the nursing council is it really appropriate for the nursing council to consider whether special schools have the need to engage nurses? I think maybe they think they have a very clear stance, but since members are very confused about the professions, they should understand that right now the professions are not very clear. Thank you. All right, Deputy Secretary. Thank you, Chair. As said before, we have liaised with the Education Bureau, and it is a consensus that we need to conduct further assessments to see if it is the case that for special schools, nurses on limited registration or enrollment would be qualified for such work. Also, we have included some social welfare institutions in the other points. And it is because we've included such institutions because we have liaised with the social welfare department because they would monitor the performance of such homes and they would conduct regular assessments of these institutions. We believe the institutions engaging non-locally trained nurses, they would be subject to regulation and thus they should be qualified in a sense and their performance can be assessed. Which is why we have already included such institutions in the other points. As for special schools, we have communicated with the nursing council. It is deemed necessary to have more regulatory arrangements in special schools before we can include them in the schedule. But let me say this, for 2C and other schedules, we have tried our best to include the institutions that we already know are in need of nurses. As for other healthcare institutions, if it is in the public interest, the Secretary for Health may by a gazetted notice designate such institutions, and the director of social welfare can also do so. And referring to the arrangements for medical practitioners and dentists, some types of employment can be specified. We believe such arrangements should be adequate to accommodate the different needs that may arise in future in relation to the engagement of non-locally trained nurses on limited registration or enrollment. As for the types of employment that the Nursing Council can specify, these are subject to conditions. That is, it must be appropriate or necessary. And I think the Nursing Council is more than adequate to make such judgment.
We do not question the professionalism of the Nursing Council, but like Ms. Rebecca Chen said, Director of Social Welfare as well as the Nursing Council can make a decision. Well, nurses are professionals. Can the Nursing Council oversee issues faced by the social welfare sector? That means apart from the Director of Social Welfare, the Nursing Council may designate any institution or allow any institutions to employ nurses under limited registration. That means the Nursing Council will be given a lot of power. Deputy Secretary, as mentioned, the Nursing Council may specify a certain type of employment. Take special schools as an example. Well, let's not talk about special schools. Let's talk about other institutions. Apart from Director of Social Welfare, the Nursing Council may allow certain types of institutions to employ nurses under limited registration. Is that right? That means the Nursing Council will be given a lot of power. The Nursing Council would oversee matters concerning not just the nursing sector, but other sectors as well. You are giving the Nursing Council a lot of power. Does it make sense to give so much power to the Nursing Council? Because the Nursing Council would be like the Director of Social Welfare in terms of the power that it enjoys. Well, this is written in the bill. That means the Nursing Council would be empowered to do so. For instance, an institution applies to the Nursing Council to employ nurses under limited registration, and under the law, if the bill is passed, the Nursing Council would have the power to approve such application. The policy intent is to empower, indeed, the Nursing Council to allow certain institutions to employ nurses under limited registration, because we want to allow flexibility in this regard. Having heard members' views, I believe after the meeting we will look into this further. You may consider having professional bodies from, say, the social welfare sector or other sector to help approve such types of applications. Say, Reverend Peter Kuhn may belong to the social welfare sector and the religious sector, and Reverend Peter Kuhn may make use of his professional knowledge to help approve applications. Would you include representatives from other sectors to help the Nursing Council to make this kind of decision? Deputy Secretary. We will see how The Nursing Council may incorporate advice or suggestions from other sectors as they are given the power to approve such applications. Yes, Ms. Rebecca Chen. Members may look at the Nurses Registration Amendment Ordinance 1997 that is tabled in front of us. There's a Section 9A. Back then, there was already limited registration. Under Section 9A, it says the Council may, on being satisfied of the person's qualifications, temporarily register such person to practice nursing. That means back then we already had a limited registration regime. It says here that upon application in writing from a person who is qualified to practice nursing in another jurisdiction may practice in Hong Kong. There has been a lack of nurses in, say, residential care homes for the elderly and residential care homes for persons with disability. Have we made use of such limited registration regime to address manpower shortage? Has the Nursing Council been exercising the discretion it has been given to allow nurses under limited registration to practice in Hong Kong? I realize from this document from 1997 that back then the Nursing Council had the power to allow certain institutions to recruit nurses under limited registration. May I ask Mr. Lee to explain to members why we tabled this document? Before the meeting through the Secretariat, we tabled the Nurses Registration Amendment Ordinance 1997. This is because when we scrutinize the bill, we can see that there are amendments to this ordinance. Please refer to page 109 of the marked-up copy for the amendments of the ordinance in 1997. We want members to be able to see how the ordinance from 1997 were drafted. That's why we asked the Secretariat to table this document before the meeting. Ms. Rebecca Chen referred to Section 8 of the ordinance in 1997. Well, in page 109 of the marked-up copy, it is mentioned that the limited registration mentioned in 1997 document would be repealed. According to Section 8 of the 1997 document, the limited such Section 9A would be added, and we haven't made use of this provision. That means you've never made use of the provision, and the newly amended provision will replace this. Well, by not having made use of it means it has not come into effect. Well, the 1997 ordinance specifies that the government will have to, by way of Gazetted, declare a date, a commencement date of this ordinance, but it was never done. So there is no part of this document that I can make use of to allow me to better understand point 5 of part 2 of Schedule 2, right? Mr. Lai Tung Kwok. Well, this Nurses Registration Amendment Ordinance 1997 was tabled to us, and it was formulated by the then Legislative Council just a few days before the handover. And it never came into effect because it was not signed by the administration. Is it still the case today that the Chief Executive has not signed this document? Well, it's a bit complicated. There are 24 sections under this ordinance in 1997. We published it in 1997, and in 1999 we allowed 9 sections to come into effect, but 15 of them never came into effect. So we are proposing some amendments to these provisions that have never come into effect. Chairman, I don't quite understand. Back then, part of the ordinance was signed and was allowed to come into effect, but part of them were not. Now, returning to point 5 of Part 2 under Schedule 2, it says that the Nursing Council would be given power to allow an institution to recruit nurses under limited registration. The power behind Schedule 2 comes from Section 2C 1B. Under Section 2C, there is a definition for a designated institution. Section 2C 1B it says it falls within any of the categories of institutions specified in Part 2 of Schedule 2. Now we are on point 5 of Part 2 of under Schedule 2. According to point 5, the Nursing Council may, by notice published in the Gazette, designate an institution to employ nurses under limited registration. You have to designate the institution. You cannot just designate the type of employment, because this is not allowed under the law. So, in any case, you have to specify or designate an institution which is allowed to employ nurses under limited registration. From this perspective, I agree with what Professor Chen Wing-Kwong said, that the Nursing Council is comparable to the Director of Social Welfare in terms of the power it enjoys. I think you should increase the transparency if you are going to give the Nursing Council so much power. The Secretary may make use of Section 2C 1B or 1C. The Secretary may even circumvent the Nursing Council if the Secretary wants to allow an institution to employ certain types of nurses. However, I do think that the administration should enhance the transparency and stick to the rules and procedures. Deputy Secretary, understood. For the Nursing Council, this is going to be a new arrangement and a new type of power that it is going to enjoy. I think we will provide a document setting out the role of the Nursing Council in this context, and whether we will include representatives from other sectors to assist the Nursing Council to make the relevant decision. I want to point out that the Medical Council is not given the power to decide whether to employ certain types of doctors. The Medical Council is only responsible for deciding whether a doctor is qualified to work under certain circumstances. According to the law, a person will have to get approval from the Medical Council. It has to have the relevant overseas qualifications. It will have to have enough clinical experience. Also, the person will have to get the license from an overseas body in order to be registered or practice in Hong Kong. Say if the doctor does not have an overseas qualification, it does not have the clinical experience after graduation, as long as the medical council accepts that the doctor is of good character, that person would be allowed to practice in Hong Kong. So the medical council is given such a power. But we're talking about the qualifications of the doctor. This is what the medical council looks at. One of the examples we mentioned is Rugby Sevens, as well as the tunnel project. Also, some doctors are allowed to work, for example, in a team of Rugby Sevens, and also doctors with limited registration. They're allowed to serve in a tunnel project. So in such circumstances, the medical council looks at the qualification of doctors with limited registration instead of deciding what kind of institutions can employ doctors with limited registrations. So you cannot make a direct comparison here between the medical council and the nursing council.
Thank you, Chair. We understand that this schedule would only empower the nursing council to designate the types of employment. In respect of which limited registration or limited enrollment is appropriate or necessary. But the nurses concerned still have to meet the conditions for limited registration or enrollment. When we give a written response, we will set out in detail the arrangements. Of course, this is a new power for the Nursing Council, so we should set out the detailed arrangements. Thank you. I think the Nursing Council would have power to see if nurses are qualified, and they can talk about which settings would be appropriate for nurses on limited registration or enrollment to work in. Thank you, Professor Chen Wing-Kwong. Thank you. When you give your response, can you also talk about when assessing the types of employment, what will the Nursing Council do? The whole process, please. Thank you. Chair, we will give such details in the response. Thank you. I think we have been talking about this issue for half an hour. Let's proceed if we have no further questions. Thank you. We have talked about Schedule 2. Now we are moving on to Schedule 3, page 63 of the marked up copy. This would relate to Section 31. Simply put, these are some transitional provisions relating to Nurses Registration Amendment Ordinance 2023. Basically, we want to make sure that existing registered nurses or enrolled nurses can successfully transition to the new regime. The first part would be interpretations. Commencement date. It would mean the date on which Section 3 of the Amendment Ordinance comes into operation. Next, appointed date means the date on which section of the Amendment Ordinance comes into operation. This will be a date designated by the Secretary in due course. Next, Amendment Ordinance. That is the Nurses Registration Amendment Ordinance 2023. The rest would be the different registers or roles, that is the definitions in the bill that we discussed earlier. On the next section, it would be registration and register. On the commencement date, an existing registered nurse is to be regarded as a person with full registration, and the secretary must, on the commencement date, transfer the name and particulars of each person whose name and particulars are contained in a part of the existing register to the corresponding part of Division 1 of the new register. When we talk about the regulations A and B, we will talk about these details. Now, third, enrollment and roll. Again, the information would have to be transferred to the Division 1 of the new roll. 4, existing certificate of registration. On and after the commencement date, a certificate of registration issued that was enforced immediately before the commencement date continues to be enforced as if it were issued under the amendment ordinance to a person with full registration, and accordingly a replacement copy would work the same. 5, existing certificate of enrollment. The arrangements would be similar to those of registered nurses. All right, please proceed. 6, pending application for registration. For applications that were pending immediately before the commencement date, upon the commencement date, the applications would continue to be processed. And if such applications are approved on or after the commencement date, the secretary must enter the applicant's name in Division 1 of the new register and issue to the applicant a certificate of registration under the amended ordinance. Thank you. Please proceed. 7 would be for enrolled nurses, and the arrangement would be the same as what I mentioned earlier. Thank you. Please proceed. 8, restoration of name to register on application. This would apply to registered nurses. This section applies if before the commencement date a person's name was removed from a part of the existing register indefinitely. The person has before the commencement date applied to the council for the restoration of their name to the original part of the pre-amended ordinance, and on or after the commencement date, the council allows the application. Specifically, if the application is allowed upon the prescribed fees that have been paid, the secretary must restore the person's name accordingly. And the certificate of registration that was enforced immediately before the removal is to be regarded as being in force. Thank you. Mr. Dennis Leung, I want to ask about 6 and 7. It may be the case that some applications that have been submitted before the commencement date and they have yet to be processed on the commencement date. I want to ask what the detailed arrangements are specifically. Thank you. Well, we do not have any difference in terms of the pending applications. That is, applications handed in before the commencement date would be dealt with the arrangements and the conditions of the pre-amended ordinance, and those that come after would follow the arrangements of the amended ordinance. Chair, I'm asking this because there may be new forms. Well, thank you. It is the case that if an application is submitted prior to the commencement date, we will deal with the application, with the procedures of the pre-amended ordinance, conditions, format, and whatnot. But for the applications that are submitted on or after the commencement date, they will be dealt with the arrangements under the amended ordinance. Correct. Mr. Lighton Kwok, thank you. I want to ask about 6 and 7 as well for the pending applications. The applications made before the commencement date are to be continued to be processed. However, for 8, it is different because for a person who wants their name restored to the register, the application would be made before the commencement date, but the council has yet to reach a decision. Which provisions are to apply? Those of the pre-amended ordinance or those of the amended ordinance? Is it the case that you would make use of the provisions in the amended ordinance to review the application to restore their name to the register? Thank you, Chair. Simply put, if an application is made before the commencement date to restore their name to the register, we would make reference to the provisions in the pre-amended ordinance. But let me say this. The arrangements, the criteria specifically, would be the same. The bill does not make any change in this regard. Chair, I think for 6 and 7, it has been made clear. Not so much for 8. So why is it that you only specify this in 6 and 7? Because 6, 7, and 8 would all relate to pending applications, essentially. You wish to provide for transitional arrangements, which is why you specifically said in 6 and 7 that the applications would continue to be processed. But for 8, this is not included. Why? Principal Assistant Secretary. Thank you. Well, 8 in particular would mean that the application would be processed with the provisions under the pre-amended ordinance. It is only the case that they would have to pay a prescribed fee. That is the only difference. For the pre-amended ordinance, regarding the processing of applications, we have made some amendments and we have included the references here. Chair, let me add something. For the restoration of name to register on application, we have not made any changes to the arrangements. The arrangements are the same as before. That's why we do not have to specify whether we're following the old criteria or the new criteria. Well, this is because the criteria are the same. I find it quite weird because there may be no change in the criteria. If you have not made any changes to the register, you wouldn't even need this provision in the first place. I understand that you would have a new register. That is why you would need the relevant provisions. I understand the difference is that the prescribed fee must be paid. Is this the only difference? Thank you. Let me clarify something, Chair. upon commencement of the bill, before there would only be a single register. After that, there would be multiple registers, and we would have to specify where to put the names of nurses. Well, so I think specifically you would have to say that the part of Division 1 of the new register, and that would be a major difference as well.
Section 9 concerns registered nurses. After the passage of the bill and after the commencement of the ordinance, the period for which a person's name to be removed ends on or after the commencement date of the ordinance. And also, according to this section, the Secretary must restore the person's name to the part of Division 1 of the new register that corresponds to the original part. I have a question. The provision here doesn't spell out clearly the procedures for persons whose name is removed. You mentioned that there will be a restoration hearing, and the Nursing Council would be given the power to decide whether to restore a person's name or not. But according to the provision here, as long as a prescribed fee is paid, a person may have his name restored instead of having to go through a restoration hearing. So I want to know, after the amendment to the ordinance, whether a person will have to go through the restoration hearing or not. I believe you're referring to page 52 of the marked up copy as well. There is a simple amendment here. And this is not a new provision because it was drafted back in 1997. For the new section 11 bracket 4, it deals with cases in which a person's name is removed without a time limit specified. If that's the case, the person's name can be restored under section 11 bracket 4. And for the 1997 ordinance, section 11 subsection 5 is added, and it specifies that once the time limit has passed, the prescribed fee will have to be paid in order for the person concerned to have the name restored. All right, please carry on. We came across sections 8 and 9, which has to do with restoration of name. For sections 10 and 11, they apply to enrolled nurses. For sections 10, it is without time limit, and for section 11, it is with time limit in relation to restoration of names of nurses. Now we come to page 69 of the marked up copy. It's a transitional provision. On and after the appointed date, a practicing certificate issued to a registered nurse that was in force immediately before the appointed date continues to be in force for the unexpired period, as if it were issued under the amended ordinance. Yes, please carry on. Section 13, page 70 of the marked up copy. It has to do with registered nurses. for practicing certificate. Section 14 is about pending application for practicing certificate. This applies to both registered and enrolled nurses. If a registered nurse and an enrolled nurse has made an application for practicing certificate before the commencement of this ordinance, then the procedure will be dealt with according to the original ordinance. Now we come to amendments to Cap 164, Subsidiary Legislation A. There's an amendment here. Section 3, subsection 1, given the new pathways, including limited registration, special registration, and temporary registration, and so on, there will be a new register for each of this type of registration. There will be divisions 1, 2, 3, and 4 for the register. We've also proposed a new section, subsection 2 here. Each division of the register is divided into different parts. There are also divisions to the existing register. In Section 3, we changed the wording in relation to incapacitated persons, and this is in line with the other legislations in Hong Kong. Section 3, subsection 1. One part is removed. By removing that part, the content listed out in the register is no longer restricted. Now we come to page 72. It is the original Section 4 under Subsidiary Legislation A of Cap 164. We propose to remove the original Sections 4, 5, and 5A. Original Section 4 empowers the Nursing Council to issue practicing certificate and formulate or come up with format for these documents. Since we have provisions dedicated to the form or format to be used, we are proposing to remove this part. We are proposing a newly added Section 5B. This is about the fees for registration and practicing certificate. There's a part dedicated to the fees because after removing the previous Sections 4 and 5, well, originally under Section 4, there's a subsection 2 in relation to payment of the relevant fee prescribed. Since that part was deleted, we are adding this Section 5B, stipulating the fees that a person will have to pay for the practicing certificate. The fees vary for persons with different qualifications obtained in Hong Kong and elsewhere. Page 75 of the marked up copy. Section 7. Fee for restoration of name to register. Page 76. There is an outdated provision. This provision has never come into effect over the years. The provision has become outdated, so we propose to repeal this provision. Page 77, Section 9, Training Schools for Nurses. There's a technical amendment. We propose to amend the wording of the registration of any nurse under Section 9, subsection 2. Into full registration. I have a small question. Here it says no course of training carried out in Hong Kong shall be recognized by the Council for the purpose of full registration unless such course has been carried out in one or more of the training schools. Does that mean there cannot be a curriculum out of nowhere? Correct? It has to be a course recognized by the Nursing Council, provided by a training school. Does that mean a student can only apply for the registration after completing the course? Currently, after a student has completed a relevant training course, the course has to first be accredited by the Nursing Council. After students complete such courses, then the training school will certify that the student has completed the course under the requirement of CAP 164, and the training school will help students submit the application. So first, the course will have to be accredited by the Nursing Council in order for it to be offered to students, and afterwards, the Nursing Council will go through the vetting procedure, right? Page 78 of the English version, original section 12, there is some amendment in relation to minimum training qualifications for examination. Yes, Ms. Doreen Kong. Chairman, I would like to ask about page 77. It says here that the course will have to be formally registered or full registration is required for such course under the Nursing Council. Does that mean there are courses that are without full registration? We have full registration, special registration, and limited registration. So we specify here that the course mentioned here is for full registration. Here I see that the original section 10 has been removed. Why is this section removed about minimum age for commencement of training? We see that there are different types of training courses offered in Hong Kong. In order to boost manpower, we do not want to specify the minimum age of students who are undergoing such training. We want to move with times. That's why we propose to remove this section. For a student to become a nurse to practice with limited registration or special registration, is there a minimum age requirement? Nursing Council, thank you. For registered nurse, the minimum age requirement is 20. For enrolled nurses, the minimum age is 21. But the minimum age requirement will be eliminated in the future, is that right? Yes. Page 78. About minimum training qualifications for examination. For the original section 12, subsection B, we are removing parts of this provision. The original subsection B says that the training course has to last for a period of 3 years. There are different types of training courses nowadays. That's why we're removing the requirement of 3 years. And we are therefore removing the B1 and B2.
呢一度咧，其實
Thank you. Next on page 79. On Regulation 16, submission of complaint or information. When a complaint is made to or information is received by the secretary that a registered nurse has contravened certain matters, we have provided now 5 additional scenarios for the secretary to submit the complaint or information to the chairman of the committee. For the 5 additional scenarios, specifically E, if a registered nurse or a nurse on limited registration or enrollment, they would be subject to certain conditions, and if they have contravened any conditions that would fall under E. Let me also say this. 25(1) in F, there is no amendment at the moment. It is about prevention and control of diseases ordinance, and if the health of a patient is compromised, a nurse will be prevented from taking care of a patient. So we have basically made a change in this regard. Sorry, I don't really understand it. Before, there is no such category for section 25 brackets 1 of the ordinance. That's why we want to catch such scenarios and put F in here. Alright, thank you. But if someone wants to complain a nurse of professional misconduct, which category would it fall into? Is it B? But the nurse has yet to be found guilty. What will it be? Oh, it would just be an interpretation. Is that correct? Yes. Alright, thank you, Mr. Kong. Thank you, Chair. I want to ask about E in particular. That is, a person has contravened any condition imposed under Section 9B or specified under Section 10A of the ordinance. Section 10A also appears in 2A and 2B. What do you mean? Do you refer to 2A 10A or 2B 10A? If you are referring to specifically 10A2, one, it is about a practicing certificate can be issued. And for the other section, it would be about some requirements that can be imposed. Which are you referring to? We're referring to the former. Well, we do not have this here in the marked up copy, right? Alright, please proceed. Thank you. We're moving on to page 18, an original schedule in the regulations. The first schedule. The first schedule is about particulars to be entered in the registered. We have in the bill empower the nursing council to specify forms. That's why we consider this schedule no longer necessary. Thank you. Please proceed. The second schedule is on fees. We have some amendments here. We want to make clear it would be a person with a qualification obtained in Hong Kong as well as a person with a qualification obtained elsewhere. Thank you. Please proceed. On the next page, it would be the third schedule. We originally planned to retain both schedules 2 and 3. That is second and third schedules. Let me say this. Form 1 is about the certificate of registration. The second form would be the notice of inquiry, and Form 3 would be the summons to witness. We originally plan to retain forms 2 and 3 because we do not consider there to be much change. But since the Nursing Council will have the power to specify forms, we may consider deleting forms 2 and 3 as well in a proposed committee stage amendment. If you're planning to delete such forms, that would be alright. But if you are planning to retain the forms, you should consider wording, because I consider some wording to be outdated. Well, I understand. Thank you. We will definitely review that. Alright, thank you. Please proceed. We have now got to page 85, and that would be the end of the regulations. That is chapter 164A. Moving on, page 86 of the marked up copy, it would be nurses enrollment and disciplinary procedure regulations. Chairman, if you allow it, I will go through this rather quickly because these provisions are more or less similar to those for registered nurses, only with the minor differences in specific provisions. Specifically for Section 3, in future they would have 4 divisions in the role. But this is different in the sense that compared to registered nurses, they would only have 2 divisions. Is it originally the case that the numbers of divisions are different? Correct. Thank you. The next major difference would be in page 93. That is Regulation 12. Before, it would say 2 years training in 1 or more appropriate training schools. For registered nurses, it would be a 3-year or 2-year period. Since we're removing the requirement for the number of years for registered nurses, we would also remove the requirement for enrolled nurses. Now, these are the only major differences between Chapter 164A and 164B. Alright, if members do not have any questions, we'll proceed. Thank you. We will now get to the consequential amendments, that is page 101 of the marked up copy. Alright, please proceed. We have made amendments to 7 ordinances or subsidiary legislation. We are making such amendments because nurses are mentioned in these ordinances, and we have consulted the relevant bureaus and departments. We have asked them, since there will be new pathways for the registration or enrollment of nurses, what their requirements would be. Having consulted the bureaus and departments, we have made these amendments. For page 101, section 33A of the Employment Ordinance, chapter 57. Before, it would say that for a medical professional, that is, it would include a nurse registered under Section 9 of the Nurses Registration Ordinance, Chapter 164, in the original provision. We have consulted the relevant department and have amended the definition to say a person with full registration, special registration, or limited registration within the meaning of the Nurses Registration Ordinance, Chapter 164. All right, thank you. Please proceed. Page 103 of the marked up copy. For Section 17 of Chapter 459 Residential Care Homes Elderly Persons Ordinance, one of the categories of the appointment of inspectors would be a nurse, and we have consulted the relevant department. We have amended the definition to say any person with full registration within the meaning, that is, nurses on other forms of registration, would not be appointed as inspectors. Let me ask this. Inspectors are not those who would be working in the institutions. They would be independent or third-party inspectors, correct? Yes. We understand that to be the case. All right, thank you. Please proceed. Thank you. Page 104 of the marked up copy. Amendments to the Residential Care Homes Elderly Persons Regulation, Chapter 459A. For Regulation 2, in the interpretation for enrolled nurses, we have amended the definition to say a person with full enrollment or limited enrollment within the meaning. We did not include registered nurses because we would only allow because we would not have nurses on special registration working in residential care homes. Thank you. Page 105, that would be the same for registered nurses. Next, on page 106 of the marked up copy, amendment to Residential Care Homes Persons with Disabilities Ordinance, Chapter 613. Again, for the appointment of inspectors, we have amended the definition to be a person with full registration within the meaning. All right, thank you. Please proceed. Page 107, amendment to Residential Care Homes Persons with Disabilities Regulation, Chapter 613A. In Regulation 11, there would be employment of staff by operators, and in Sub-Regulation 2E, it says specifically for a nurse that is to be employed, there is certain requirement that would have to be fulfilled. Having consulted the relevant department, we have amended the definition to say a person with full registration, limited registration, full enrollment, or limited enrollment within the meaning of the Nurses Registration Ordinance. Let me also preview this. We will make some technical amendments in due course. We believe we will propose further committee stage amendments in future for this regulation. All right, please proceed. Page 109 of the marked up copy, amendments to Nurses Registration Amendment Ordinance 1997. As said earlier, we have asked the Secretariat to table the relevant amendment ordinance for members' reference. There are some uncommenced provisions, and we plan to commence the provisions along the passage of the bill. And these will come into effect when the provisions of the bill will come into effect. We have some amendments, however, for the 1997 Amendment Ordinance. And we have set out such amendments here in the bill. For certain provisions that are no longer necessary in the 1997 Amendment Ordinance, we will repeal such sections as well. Please proceed. Thank you. Page 109 of the marked up copy, Section 6, correction of the register. We have proposed to amend 7(3) in earlier provisions, and Section 7.3 would involve certain amendments, and this Section 6 would repeal Section 7(3) as it has been incorporated in earlier provisions in page 14 of the marked up copy. We will repeal this section.
Back in 1997, it was suggested that Section 8, bracket 1, bracket 8 is to be repealed under Section 7. This is to do away with the minimum age requirement. We have incorporated such an amendment in the bill. You may refer to page 16 of the marked up copy. Since it's incorporated, so we propose removing Section 7 of the 1997 ordinance. Section 8, it is to add Section 9A, limited registration. As mentioned in the discussion just now, there will be new admission pathways. Therefore, we think that the old Section 9A for limited registration is no longer necessary. Mr. Dennis Leung, Chairman, I am looking at Section 5 of the 1997 ordinance. It is to add Section 4A, establishment of committees and subcommittees. Is it the case that you are not going to deal with Section 4A? For Section 4A, which was proposed to be added, it's going to come into effect through this bill. We don't plan to, however, amend Section 5. That's why we are not including it in this bill. We will, through negative vetting, allow this provision to come into effect. That means this part won't be included in this bill, but afterwards it will come into effect through negative vetting. That's right. And when will the negative vetting take place? For provisions that need to commence under Ordinance 1997, we want them to come into effect on the same date as this ordinance. We will pay attention to the time and process needed for negative vetting. So the idea is that you will have the amended ordinance as well as the provisions that have yet to come into effect under 1997 ordinance to take effect on the same date, right? Now we come to page 110, Section 10 of the 1997 Ordinance. Persons not to practice as registered nurse without practicing certificate. This is a requirement that was proposed back then. Such a requirement is incorporated in Section 10A of this bill. If you may refer to page 17, it is included in Section A, subsection 2C. Since this part is included in the bill, we propose to remove this from the 1997 ordinance. Section 11, correction of the role. It is to amend Section 13, subsection 3 of the Nurses Registration Ordinance. This is similar to the case in Section 6 of the 1997 Ordinance. Section 6 concerns correction of the register, and Section 11 concerns correction of the role. Again, this has already been included in the bill, so we propose to remove this from the 1997 ordinance. Section 12 is about qualification for enrollment. Same as what was discussed, we propose to remove the minimum age requirement, so this section is no longer necessary. Page 111, Section 14. Person not to practice as enrolled nurse without practicing certificate. This corresponds to the situation under Section 10. And again, we propose to remove this part. There are a few provisions that we want them to come into effect, but they need to be amended. They are sections 15, 16, 17, and 18 under the 1997 ordinance. The original provision of section 16 to 18 mention a fine of $1,000. After the bill is passed, we will mention level 1 fine instead of a fine of $1,000 in the provision. In any case, the penalty will be increased from a level 1 fine to a level 3 fine, which is $10,000. So we have to amend the provisions from the 1997 ordinance. Page 112, there are sections 17 and 18 from the 1997 ordinance. Again, we are changing the fine of $1,000 to a level 1 fine. But it doesn't matter because the level of penalty has been revised after 1997. Now let's go back to section 16, provisions relating to orders of the council. This is clause 21 of the bill. If you may refer to page 52 of the marked up copy. It is about restoring some names on the register. We have changed that part of the provision. In the future, section 21, subsection 4 will deal with removal of name from the register without time limit. We're adding section 21, subsection 5 to deal with removal of names from the register with time limit. So there will be two different subsections here to deal with the two types of scenarios. Now going back to page 112, we are removing section 19 and section 24 of the 1997 ordinance. Section 19 is about exemption for registration. This part has been included in the bill, so this is no longer necessary. Section 24 of the 1997 ordinance is about repealing certain provisions. The original purpose is to repeal two subsidiary legislations. We checked some literature and documents, and it was up to the Nursing Council to deal with the two subsidiary legislations. However, we think it is necessary to retain actually the two subsidiary legislations, so we will remove section 24, which proposes to repeal the two subsidiary legislations. Now we come to some other amendments. These amendments are related to the amendments proposed on page 107. Page 113 concerns the Residential Care Homes Legislation Miscellaneous Amendments Ordinance 2023. This part of the bill is to amend the Residential Care Homes Ordinance. Originally, the plan is that the bill may be passed before 2023. If that's the case, we will have to amend the Residential Care Homes Ordinance 2023 in order to reflect the situation. However, this ordinance will only come into effect in June. We believe this particular bill will only take effect after 26th of June. We will have to amend this Residential Care Homes Ordinance, and we will table the amendments to members later. Legal advisor, are there any issues with the English copy? There are no drafting issues in relation to the English copy of the bill. We have completed the scrutiny of the bill. There will be committee stage amendments from the government. If that's the case, please allow members to take a look at the CSA as soon as possible. Do members think that there is a need for another meeting? Do we have to hold another meeting to go through the CSA? How about we look at the CSA first and then we decide whether there is a need to hold another meeting? AOB. Well, we haven't decided yet whether there is a need to hold another meeting, so we haven't set a date for the next meeting. There being no other problems, meeting adjourned.